Hello guys, welcome to our channel LNC Pro. In this video we will see rights of surety. Basically, rights of surety can be seen under three heads: rights against the creditor, rights against the principal debtor, and rights against co-sureties. Right against creditor includes right to securities that is given under section 141. Right against the principal debtor includes right of subrogation, which is given in section 140, and right of indemnity, which is given under section 145. And right against co-sureties is also known as the right to contribution, which is given under section 146 and section 147 of Indian Contract Act. So these are the main rights available to a surety. And I would recommend that before watching this video, please watch our earlier videos on contract of indemnity and guarantee, so that you can easily understand this video. You will get the link in description. So let's start by seeing rights against creditor that is given in section 141, which is known as right to securities. According to section 141, a surety is entitled to the benefit of every security which the creditor had against the principal debtor at the time when the contract of suretyship is entered into. Knowledge of surety about security is not relevant for availability of this right. Let's understand section 141 with the help of an example. A goes to B and asks for a loan of $2,000, for which C is the surety, but B says only guarantee is not enough. What will I do if A does not repay? A gives his gold as security and B gives the loan. When A failed to pay the amount, B recovered the amount from C, who is the security. After C has paid the debt, he can take the gold from B. This is known as the right to securities. Now let's see the right against the principal debtor. Mainly there are two rights available against the principal debtor. First right is right of subrogation. This is given under section 140. When the debt has become due, or when a default is made by the principal debtor and surety has paid the amount, the surety will step into the shoes of the creditor. That means surety will get all the rights which the creditor had against the principal debtor. Second right against the principal debtor is right to indemnity that is given under section 145. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. According to section 145, the surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the contract of guarantee. To understand the meaning of contract of indemnity, you can watch our video which you can see on the screen. You can find the link of the video in the description also. Now let's see rights against co-sureties, which is known as right to contribution. This right can be divided in two parts. First is when the co-sureties are liable to contribute equally. This is given in section 146. Second is when the co-sureties are bound by different sums. That means when co-sureties have undertaken guarantee for different sums. This is given in section 147. Now let's see section 146, when co-sureties are liable to contribute equally. When two or more persons are co-sureties for the same debt, whether under the same contract or different contracts, and enter whether with or without the knowledge of each other, they are liable towards each other to pay an equal share of the whole debt. Let's understand this with the help of an example. These three people are co-sureties for a loan of $3,000 given by D to E. And when E fails to pay, all these three sureties will be liable to pay $1,000 each. Now let's see section 147. When co-sureties are bound in different sums. According to section 147, co-sureties who are bound in different sums are liable to pay equally as far as the limit of their respective obligations permit. Let's take an example. A, B, and C are co-sureties for a loan given to D. A has guaranteed up to $10,000, B has given guarantee for an amount up to $20,000, and C has undertaken liability up to $40,000. When D makes a default of $30,000, A, B, and C are liable to pay $10,000 each. In the same example, suppose D makes a default of $40,000. In this case, A will be liable for $10,000 as his obligation is up to $10,000, but B and C will be liable for $15,000 each. Again, suppose D makes a default of $70,000. Now A will be liable for $10,000, B will be liable for $20,000, and D will be liable for $40,000. Thank you for watching our video till the end. If you haven't subscribed our channel, please subscribe it. If you like our videos, share it with your friends and comment your suggestions. You can follow us for lectures on law subjects, company secretary, chartered accountant, and cost and management accounts. Thank you.